And you told me about how you just. I asked you what were you looking for because you were made the chair of that
That's right.
group,
Yeah.
and I asked you what were you looking for in these law firms.
Well, it's not all my ideas. I worked with the chiefs, with the committee, to determine just what we need. What kinds of things do we want a law firm to understand and to do for us to move this case forward? So we took all of those ideas and I drafted them into a request for proposals. We gave it back to the chiefs in assembly, and the chiefs agreed with it, and they said, yes, this is the process that we should go to. So then we asked the chiefs, rather than send it out to all across Canada, we said that's not very productive. We should be selective in who we think.
So very strategic. At
That's
this
right.
point.
Who we think would be good lawyers, law firms to take this case on. And so we had, I think it started out with 11 legal firms answer the call. We narrowed that down to six law firms, and those 6 law firms, what we did then is we gathered around a table, and the litigation working committee took the time to review the submissions based on a set of criteria that I had developed because we had all these principles that we wanted there. So I developed a criteria and a scoring mechanism so that we could determine which law firm would be the best for us to approach to take this case. So we did that, and we came up with a law firm, and we presented our findings to the chiefs. The chiefs agreed to it, and they asked us to, contact the law firm and to bring the law firm to a meeting with the chiefs. And the process started to move forward.
And to me, when you talked about this sounds like this is when things started moving quickly.
That's right. Yeah. The law firm that we engaged is a law firm of Nahwegahbow Corbiere, and they're currently headquartered out of Rama First Nation. And they brought some ideas about how, when they first came on, they saw the problems that we were having, trying to unite all of the First Nations to get together. And it wasn't easy to do that. There was a lot of different issues, and there was this constant changeover, chiefs and counselors, and each one coming back in and different ideas, different ways of doing things, and we just kept having to take steps backwards and start again, and so anyway, the law firm came up with this idea of creating a trust and a board of trustees that would be given the mandate to take the case forward into court.
So empowered by the chiefs.
Empowered by the chiefs.
And trusted by them so that not every decision
That's
had
right.
to be made by committee of the whole.
That's right. And they drafted a trust indenture. We reviewed that with the chiefs, went over it line by line, and in the end, they all agreed that this was the process that we should use to move the case forward. What that did then, it took it aside from what the chiefs were normally doing. So it didn't matter whether there would be turnover amongst the chiefs and councils. This trust continued with the work. There was no interruption in the work, and it just continued. There was difficulties in getting funding. It was difficult for the First Nations to provide money to the trust to keep the work going because, hiring lawyers, hiring researchers, historians to gather evidence to prepare the case for court is a huge undertaking. It was a huge undertaking.
And this is coming out of those 21 nations' pockets.
That's right. That's at the start, and we did that, and we got, we ended up we got enough money from the First Nations to at least to do the research and to pay the lawyers, and the lawyers were really good. The lawyers agreed with us. What we did is we negotiated a partial contingency arrangement where the lawyers would work for half their salaries to work for us to get the case into court, but in the end there would be a contingency to so that they could recoup their salaries in the end.
So that must have felt like a vote of confidence to you.
That's right.
Do you know what I mean? If they're willing to do that, that must have told you they feel like they've got a chance at this.
That's right, yeah, because what that law firm did is they gave us 5 different legal opinions on the case, and they said that this case looked really solid to them, that they had a really good chance to win this in court. So when we brought this trust indenture to the chiefs, they agreed to that, and that was in 2010. We established the Robinson-Huron Treaty Litigation Fund, of which I was appointed the chair.
There's a theme. I'm seeing a theme. I want to back up a little bit. You talked about, because one of the things that happens, you've talked about one struggle going forward, which was the constant re-education and, I guess, re-lobbying of the new leadership, because and I'm assuming it was the Indian Act that was forcing the communities to re-elect the leadership every 2 years.
That's right.
Right? So this isn't a conversation about that, but that is a colonial strategy to undermine the political authority of Indigenous folks, is to destabilize the leadership. And so we've got a group who is seeing that strategy and recognizing that the way to resist the strategy is through patience and perseverance of a kind of unbelievable level. You identified another snag along the way, and that was that there were 17 communities that signed the Robinson-Huron Treaty, but by now there are 21 Robinson-Huron communities, which makes it confusing to figure out who is part of the law case and in what status, what their status is.
Yeah. The treaty talks about communities along the north shores of Lake Huron and Lake Superior. And at the time that the treaties were made, those were the people that they talked with. Those people that were... So there were people living on Manitoulin Island who were not engaged in the process.
The 1850 process.
That's right,
yeah.
The 1850 process. So what happened then is since 1850, our people scattered all over the place, and they became members of all these different communities, and these different communities became First Nations under the Indian Act, and these chiefs and councils became responsible for the members, some of whom were treaty annuitants, people that were entitled to the annuity on a yearly basis, and so we had to find a way to deal with that. Well, some of the First Nation communities said, no, this is only about the North Shore communities, not about the ones on Manitoulin Island. It was about the North Shore communities. So there was kind of a division there, and it was really a tough situation to get over. We engaged a historian to look at what happened in the past as to why some of these First Nations, some of these communities became First Nations and were included under the Robinson-Huron Treaty. And there were such things as adhesion, things like that resulted in these First Nations coming within the terms of the treaty. So there was a difference of opinion as to who are the real holders of the treaty. So what our law firm then, when they came out with this trust idea, it was, instead of taking it forward based on 21 First Nations, we would take it forward based on the beneficiaries that live in these communities. So it's like a class action lawsuit,
Right.
really is what it is, but it's based on a representative action, is what the legal term that they used. So the representative action was based, was put forward as a way to encompass all of the people in the First Nations. So naturally, because there were, the people in those communities were governed by their chiefs and councils, we had to include all of the First Nations as decision makers on the process going forward. So that's how we were able to pull the First Nations together.
And I love that story because it's so, on the face of it, that 17 versus 21, it seems sort of like a deal breaker. That could have been a deal breaker.
It was a deal breaker for a good while.
And not just because people are stubborn or it just seems real hard to get around that. So, and it was such a intelligent, thoughtful, and unifying strategy.
That's right. Yeah. So this innovative idea that Nahwegahbow Corbiere law firm came up with, and the chiefs accepted it, gave us a good process to move forward with the case. So then the trust then was given the mandate from the chiefs of the communities to carry the case forward into court.